Welcome back to the China Law 101 video series. I'm your host, Edgar Choi from Law in a Minute. In today's video, we will talk about whether a divorce agreement may state no remarriage. Let us first acknowledge that such an agreement would be deemed invalid as it infringes upon mandatory legal provisions. Divorce and marriage are matters of personal freedom, and no agreement can exclude the statutory rights granted by our legal system. Prohibiting a party from remarrying or having more children after remarriage contradicts the fundamental principles enshrined in our Constitution and marriage laws. Thus, any provisions of this nature would be considered null and void. However, let us approach this issue from a different perspective. Rather than imposing restrictions on personal choices, we can view these provisions as a mutual agreement to specify the conditions under which custody rights may be altered. In the event that circumstances arise where the other party remarries, custody rights would automatically transfer to the other parent. It is important to note that the effectiveness of such an agreement cannot be universally determined. The decision would ultimately rest with the judge presiding over the case, who would carefully consider various factors from both parties involved and make a ruling based on the best interests of the child. In cases where amicable solutions cannot be reached through mediation, the judge will assess the unique circumstances presented and issue a judgment accordingly. Now, let us delve into legal provisions that allow for modification of child custody rights. The first circumstance involves a situation where the party residing with the child is unable to fulfill their parental duties due to a severe illness or disability. In such cases, it is crucial to gather medical records or evidence that substantiates the inability of the other party to adequately care for the child. If necessary, one can apply to the court or seek the assistance of a lawyer to investigate and verify the situation. The second circumstance arises when the party residing with the child fails to meet their parental obligations or engages in behavior that is abusive or detrimental to the child's physical or mental well-being. In such cases, it is vital to collect evidence that demonstrates the failure to fulfill parental duties. This might include documenting harmful habits such as alcoholism, gambling, or other detrimental behaviors. In cases of child abuse, it is important to report such incidents to the appropriate authorities, such as the police. Gathering evidence, such as the conclusions, opinions, and photographic evidence of the child's injuries can bolster the case for a custody modification. The third circumstance involves situations where a child over the age of 8 expresses a voluntary desire to reside with the other parent who possesses the capability to provide proper care. In such cases, effective communication with the child becomes paramount. Engaging in open and honest dialogue while respecting the child's wishes is crucial. Should the child willingly express a desire to live with the other parent and that parent is equipped to provide suitable care, one can seek a modification in custody. It is important, however, to approach such situations with sensitivity, ensuring that the child's preferences are not unduly influenced or manipulated. Thank you for watching today's video. Please feel free to share your thoughts in the comment section below. Stay tuned for our next episode where we will talk about how individual income tax is calculated.